I think for us to talk about digital health and specifically a framework for this country, it is important for us to also pay attention to the context within which we operate. I've had an opportunity to work with developers or technology innovators or people that are really trying to find solutions. And a couple of things really like stand out. One is that the people that attempt to build technology for health, majority build out of gut feeling. You find somebody who walks into a hospital and realizes there should be an app that helps you to create an appointment, and will immediately start building it, and it is collecting all sorts of data about the patient and has no idea about data privacy, has no idea about how you manage that transmission, and the whole mix of things that come with it, but also the general context of understanding how healthcare operates in this country, that even moving data from one clinic that is on the same network is a burden. Every time you visit a hospital, you're a unique identity. You're a unique patient, if I could put it that way. Even in hospitals where you think you have a file, and so the structural challenges that come with it sometimes inhibit ability to innovate. Two is leadership and governance. But I'll start with leadership. So where we've had an opportunity to see opportunity where you're like, this could potentially change what we are doing in the healthcare space, you then hit a gatekeeper who is a professional, who looks at this and does not see their role very clearly, and therefore kind of stop you from progressing, because in one way or the other you need clearance to go to the next level. And there are several young people that I've worked with. Some of them have abandoned their ideas, have won global recognition, but recognition is one thing. If you get an award and you're recognized you're the best and walk away with $1,000, when you actually need $2 million to get the product to the market. And that's one of the things I've been trying to tell the guys here, that yeah, it is exciting to be recognized, to be put in the newspapers, but you need money to get the things working. There are certain things that cannot depend on goodwill and people praising you. There are certain things that actually need money, they need investment. And so from a governance structure and leadership, until such a point where innovation or digital health specifically becomes a national agenda, then it will be very difficult for a number of young people that are trying to venture into this space to break through. And my last area of just to start the conversation is the whole space. What does digital health mean? And who are the players? Who are the actors? How do we then create a space where we can co-create? I spent 12 years in Makerere University working in the College of Computing. And I had one experience that led to my decision, close to, I need to leave this place. And that was when a computer science student, attempted to do a project with an engineering student. And we were happy for them to do it together. I was supervising the team, so I had leeway to say, yes, it's possible. And the engineering professor said, not while I am supervising this project. He has to do, you can work together, but you have to do a totally independent report. And until universities break silos, until we see co-creation happening, because an IT student who does 3 years at the university and hardly has an opportunity to interface with a medical student, but wants to build technology for health, is a waste of time. So we need to come back to some of these spaces and say, how do we then begin to nurture building stuff for digital health if in our training structures, these guys are seen in different silos?
Innovation really means to create, to be innovative, to be creative, to bring something new, something which did not exist. It could be something which we say is original, or something which is new. The two may mean the same thing, but they really are different. Something which is new is something which did not exist before. For example, when we were born, we didn't exist before. So we can say that we were newborns because we are in fact new. But something could be original insofar as it is not copied. So there's something nearer to that, or something which exists. It's not the same, and it's protected because it is a result of some level of energy, intellect, time, resources, etc. So when we talk about innovators, we are talking about individuals who take their time, expend resources. It could be time, it could be brain work, it could be resources, money, to try to get something new. So when we talk about intellectual property, we talk about the products of human intellect or human endeavor, to the extent that there is no copying. And because we're talking about property, property ideally connotes rights. If I have my phone, I have a right in my phone because it is my property. So when you add the two and say that it is a product of human intellect in which you have a right, it means that for all individuals who take time to create apps, as they may be, speeches which are written, patents, etc., they have rights in that property. And by having rights, it means that they can regulate the way that property is used. So if my colleague here went and created an app, the e-health, if that's the name of the app, that's what I had, it means that he has got a right to determine how that app is going to be used. He has a right to say, to determine how it will be used. He may determine how or who will use it in different ways. It can be economic, meaning that it may be exploited for revenue, or it might be what we call moral, if you talk about in a copyright sense, that I don't quite need money, but I need to be recognized as the person who brought about this. And I'll talk about that briefly. So by owning this property, the intellect, it means that if anyone invades your space in terms of owning that property, then again, there is a mechanism in which you can exclude that person from using it. And if they have abused it, then through the appropriate procedures, you may get relief in terms of monetary compensation and what is called injunctions to stop the person from using it. So when we talk about intellectual property law, because I've been talking about intellectual property, we then speak about the mechanisms in the law that are in place to ensure that a person who owns intellectual property is protected. The protection really comes from excluding others from using that property in an undesirable manner. Undesirable meaning, in the first place, without the permission of the owner of that property. I hope we are together that far. Now, essentially going back to the topic, what does intellectual property law mean to the innovator? The quick answer is that intellectual property law offers protection to the innovator. So for the individuals I had here before this session, all of them have, in their view, created work. We call it works. Depending on the different mechanisms in the law, that work may be protected in one or more than one form. And I will just give examples. In Uganda, because we are in Uganda, the protection exists under written law, which we call statutes, passed by the legislature, that is parliament. And because of our history, we do have a branch of law which is called common law. It is not written. If I try to explain it, to bring it home, is that all of us, where we come from, have got customs. One of the customs from my society is that you cannot marry someone from your clan. It's not written anywhere, but it's an abomination. So common law is essentially English customary law, passed on to us by virtue of our history, as having been a colony of England. In the realm of the law, it's passed on to us by case law. So when we go to court, there are some cases we'll refer to, and the judge will refer and say, yes, that is good law. So it's not written, insofar as it's not in a statute, but it constitutes law insofar as it is persuasive. When we go to the statutes, and this is where the innovators may take keen interest, one of the ways of protecting these works is copyright. Copyright is simple. Is that when I speak, when I prepare a brief note for my presentation, this one, because I said it's original, I haven't copied, it is copyright. It's a different form of work. When I'm speaking, it's also a form of copyright, but derived from this work. So if any of you is recording what I'm saying, yourselves are creating your own copyright, because you're expending energy to capture what I'm saying into what is called material form. It's something which is tangible. I hope I'm understood. I'm trying to be... Essentially, it is a reward for time, resource, and energy. What discounts copyright is copying. So if I create my work from looking at his work, then it's not copyright. It is immaterial, the volume of work I adopt from him. It's about the quality of work I adopt from him. If I am stuck and I can't get on, and I peep and I see something which takes me to the next step, then perhaps I have copied. So I'll give an example. One of the cases we handled in court, it did not take off because the parties sought to settle, was regarding a mobile phone application, which I assume we all use, which is called Me to You, the airtime transfer, whereby it was exchanged after several demos with a mobile phone company. The inventor was asked to sell their idea. They didn't think they should sell their idea. And like he said, they thought about the long haul and decided to go for a revenue share. But what happened is that the person lost interest, the intending purchaser lost interest and did not speak to the inventor again. And one Monday morning, as you all know, there were big billboards to say, X and X introduces Me to You. We went to court, and it was a very simple issue for the judge to determine, because from the green room of the mobile phone company, they had tried as much to get a similar application. And it was just an issue of the judge comparing the amount of effort. And what he told the mobile phone company is to explain why, having made several attempts over 3 years, and having failed to get such a solution, and having seen what this person had done, in 3 months they now had broken through. The IP aspects in copyright was in regard to the computer program for that application. So a computer program in your application, in your e-health applications, or whatever I have of here, can be protected under the law of copyright. Copyright protects, like I said, many things: speeches, lecture notes, demonstrations, illustrations, designs, audio-visual works, art, encyclopedias, directories, etc., etc. That is also a subject, that is subject protection. The other one is trademark. All of us here can see the map of Africa and the letters IDI. If that is a logo adopted by IDI for their services, it too can be protected and therefore exclude someone from doing something similar to that. The aspect about trademark law is that it shows it's a badge of origin. So when I see a presentation of this nation and I see the blue map with different colors and IDI, then I know it's IDI. So if someone who is not IDI picks that, I can then complain that they are misleading the public insofar as they are using my logo. So the name given to an application, for that matter, can be a subject of protection as a trademark. So you get protection in the source code or the computer program. You get protection in the design, the workout, the hardware setup, and you can even get protection in the name so that no one can use a name which is similar to yours. Trademark is also quite generous. What you can protect can expand from words, symbols, slogans, logos. A sound can be protected. A smell can be protected. It's now possible to protect a smell. For those of you who've done chemistry, the easiest I can relate it to when we were in senior 3, we studied, I think it was moles, and we used to write things of CH, very many things. Alkanes, alkenes, alkali, alkaloids, those things. So you find that for those who work in labs, it is possible to relay a scent of a perfume using that formula. The requirement is that be it a symbol, a slogan, a logo, a sound, a smell, a color, a brand, a label, all that is required is that it can be presented graphically, that's in 3D. You can write it, present it, it can be seen, and it is capable of distinguishing a product from another one. Closer to home, and in regard to the subject, is what are called patents, utility models, and technovations. Patents are about inventions. I mentioned original, and I mentioned something which is original and something which is new. A patent protects that which is new, insofar as it has never existed before. It is a reward for inventiveness. An invention is something which is new. So, the test for what is new is, in technical speak, is what is called the prior art. When I talk about prior art, and I'll make it very simple, is that if I'm inventing, for example, a mobile phone application, the measure of whether it is new will be what is known about that application in the whole world. So it is possible that an application will be defeated if perhaps similar information exists in a small laboratory in Afghanistan, because then it's part of the art. You're not inventing anything new. It already exists. But patents relate to products and also relate to processes. So you can invent a process, you can invent a product. Of course, there are some things which are not the subject of a patent. For example, it is not possible to patent a method of treating people. I mean, if someone had a monopoly of injecting using a needle, then we would be in trouble, because he may say, because I said someone has a right to say you will not inject him, then perhaps there would be a problem. You cannot get a patent over a human being. So clones, it is against public policy for me to allege that I own her insofar as she's my property. I invented her. So those are natural processes. That's why we go back to that aspect of human intellect. So processes, drugs are a common example. When I say Panadol, assuming it has a patent, you cannot patent the method of swallowing Panadol by oral administration, because again, that would be problematic. There are what are called utility models. These didn't exist before. I'll just give a definition. It's a long one, but just so that we try to understand, because I take it that it is possible for utility models under the new law to capture or to provide for a buffer between the high test for a patent and the lower test for a utility model. The law says it is any form, configuration, or disposition of element of some appliance, utensil, tool, electrical, electronic circuitry, instrument, handicraft mechanism, or any object, or any part of it, allowing a better or different functioning, use, or manufacture of subject matter, or that gives some utility, advantage, environmental benefit, saving, or technical effect not previously available in Uganda. I have said that when you look at a patent, it must be something new. Something may not be new insofar as it doesn't exist in the world, but the law says if it is not available in Uganda. So it narrows down the scope of making an assessment of whether that can be protected. So essentially an improvement in technology, taking something to the next step, can be a subject of protection. Last, the other ones, and as I wind up, what can be protected which is not in a statute. The general one, which may apply to all of us, is what are called confidences or confidential information. I did sometime come across individuals who alleged, they were students in Makerere, they alleged that they invented they had a name for it and gave it to another mobile phone company, whereby if you didn't have airtime, they developed an app where you could borrow airtime. So the next time you load airtime, the amount you borrowed is cut off. They sold the idea to a teleco. The teleco bought the idea, gave them a good agreement, but the challenge in the agreement was that in case of a dispute, this matter shall be arbitrated in Geneva. You see, the young men who are 3 told me, we have never even flown to Nairobi now, what is Geneva? So, information disclosed in confidence. If he's an inventor and he makes a disclosure to a prospective customer, that information, to the extent that it has confidential value, it is not information which is what we call commonplace. It's not readily available. It is clearly an effort of intellect, can be protected. The requirement is that the person to whom it's revealed must know that it's confidential, and it must have value. It is hard to measure value, and normally we use someone skilled in the art. Information which is an IT program in binary language 1010 may not make sense to me, but to a computer person, it means everything. So that can be the person who can assess value. And the other one is what is called passing off. Passing off is something close to trademark law. If my trademark has expired, I haven't renewed it, or if I cannot register something as a trademark, but I use it over time, the law stops anyone from purporting to use that one without my permission. So the key things for inventors lie with patents, but patents we have to be careful as innovators because it is possible for you to defeat your own patent. It's what is called self-anticipation. The common case we read about is that the person who invented a ballpoint pen, the invention about the pen was that a person developed what is called a groove. In this casing here is a small groove which allows ink to flow from the tube to the ballpoint, so that when it rolls, ink smears on it and then it writes. It took a lot of time, but the person excited about their invention gave it to 3 friends to go and write to see what he had done. And having given it to them, applied for a patent. And they told him that he had anticipated this application because then it became available to the public. It wasn't new because at the time he applied, the pen existed. It was a material that he had created it. So 2 things are important to inventors and innovators. How do you disclose your works? If you won't find it necessary to go to a lawyer to prepare an agreement, just write a footnote in your document that the information contained here is confidential and shall not be used for any other purpose without my permission. That is enough to protect you in confidence. And if it's an innovation which is patentable, then the person who receives it will be bound. so that if they go ahead to use it without your permission, it does not amount to anticipation. I hope we understand now. The easier way, of course, is that if it's a utility model, or the first thing you do is write a small non-disclosure agreement. Don't disclose this information except if I've authorized you. Thank you for listening to me.